All right, question on the record, and this is Bell County Calls number 286,540-E. This is in the 426 Judicial District Court of Bell County, Texas, and is in the interest, and how do you pronounce that last name again? I'm sorry? Kuyate. Minor child. Non-custodial party is Mr. Colonel Kuyate. Custodial party is Rochelle Griffin. NCP is present here in court today, and Ms. Griffin is present via Zoom. This matter is before the court on a motion for enforcement of child support and medical support order that the court had previously rendered in this matter. And the court will know for the record that the NCP has previously been noticed and served. He's filed several written responses, including appearing last month at at the prior hearing that reset this matter to today's date. And did appear at that, and did specifically state that he was not requesting court-appointed counsel, which he was entitled to in this matter. Anyway, this matter is now before the court on the motion for enforcement and the responding information provided by the non-custodial parties. So at this time, I'll ask the state for an opening to tell the court what the state's requesting we do here today, and allow the non-custodial party, Mr. Kuyate, to make an opening statement in his own behalf, since he is representing himself at this time. Thank you.
Thank you, Your Honor. So the state is requesting an order confirming the child support arrearage, confirming also medical arrearage, although that's zero. We're also seeking to hold Mr. Kuyate in contempt, and ask, Your Honor, 180 days in jail, cash bond of $2,000. State understands that the main issues today, I think, are going to be essentially he is alleged in pleading several jurisdiction issues, and the state is opposed to all of those. State understands that the court, well, first of all, this court has jurisdiction because there was a final order. The last final order was the child support review order, confirmation of arrears, and modification, and that continues on. I've got family code sections, Your Honor. Texas Family Code section 155.001, where A, where accepted otherwise provided by this section, court acquires continuing exclusive jurisdiction over the matter provided for by this title in connection with the child and the rendition of the final order. And then 155.002 says that except as otherwise provided, etc., a court with continuing exclusive jurisdiction retains jurisdiction of the parties and matters provided by this title. And then 155.003, court with continuing exclusive jurisdiction may exercise jurisdiction to modify its order regarding managing conservatorship, possession and access to child, and support of the child. Although the state isn't seeking to modify current child support, we're only seeking to, confirm arrears and get repayments on those. And Family Code section 157.001 is specifically for enforcement, saying subsection D, motion for enforcement shall be filed in the court of continuing exclusive jurisdiction, this court. And then I know he raises several other jurisdictional arguments. The state has case law in the interest of CAQ. I have a copy. I've presented a copy to Mr. Kuyate, and Your Honor, would you like a copy?
Yes, please. Thank you.
It's a bit faded, but I think we can still read it.
Thank you.
If we look at, especially if we look at pages 2 through 4, those are going to be the main arguments, and it's a very similar case. Then in that case, they argued that several federal statutes, prevented enforcement of all this. It extensively cites from a Supreme Court case back in 1987 called Rose v. Rose, and essentially says that federal law does not prohibit us, for current child support, doing for the appellant's disability, veteran disability benefits. It does not prohibit a state court from determining a veteran's child support obligation or state child support enforcement laws, essentially. And if we look, Your Honor, Texas Family Code 154062, B5, it includes all their income after being received, including et cetera, U.S. Department of Veteran Affairs disability benefits other than non-service connected disability pension benefits as defined by 38 U.S.C. section 101.17. So based on all of that, Your Honor, state argues that you do have the power to enforce the last order, the child review order, set repayments on the arrears, hold Mr. Kuyate in contempt, and the state would prefer, 180 days in jail, cash bond $2,000. And there's one other issue related to this. State understands that that the custodial parent gets allotments because of his veteran's disability.
Apportionments.
Apportionments.
Correct.
Apologies, Your Honor.
No problem.
We did an adjustment back in August that took care of up to then, but we don't know anything about afterward. He did file a document that, while it redacted a lot of stuff, it did mention that $140 payments, but state does not know if custodial parent should receive those. State is willing to give him a credit for those on his arrears. So if we decided to confirm arrears as of yesterday, that would be $19,899.56. If we subtract, assuming the last 8 months, mom has been getting the $140 payments contained in that filing. I don't remember what the filing's called, Your Honor. It's there. Shouldn't have been too far away. But that total with, giving $140 credit 8 months would be $18,779.56, and state would like a repayment of $144 per month starting May 1st, 2025 on that. Assuming, of course, she actually is getting that. But she understands that Mr. Kuyate is essentially opposed to all this. I don't think he wants credits for it. If he doesn't want it, then, the state's not going to push it, but state is willing to give him that. So 140 for 8 months. I think I gave you the subtracted total would be $18,779.56.
Yes, you did. You gave it to me.
All right. And the dates, Your Honor, for the punitive contempt would be looking at the dates before our motion was filed in November 2024. So August, it would be June, July, September, and October 2024.
Anything else, sir?
Your Honor, there is one other thing. So the state was thinking about asking for coercive contempt. As well. Right. And that'd be 3 months of what his current support is. $2,034. $2,034.
All right. Anything else, sir?
And then the court costs, Your Honor. He is a veteran, so I don't think anyone's disputing that. So, and then Your Honor, I don't see any family violence in this case, so I don't think we pled for non-disclosure, but I can confirm with her if it's, if she has any safety concerns, so we want that.
All right, thank you. All right, yes, sir, your turn.
Okay, so what's your name, sir?
Walter Welch, sir.
Okay, so the state attorney, Walter Welch, just stated out of his own mouth, I unless if we're talking about service-connected disabilities. I'm not retired. I'm 100% disabled veteran. I never received due process, just like the state attorney just stated. So that means, and I got my apportionment rule in 2024. So all prior orders before that without due process are moot. They're not properly conducted. I mean, I'm just.
Okay, sir, I've got final orders in this matter that had not been contested long before this thing was filed. Once they became final, sir, they're not moot anymore. They are final. There are orders that ordered you to pay child support. And that became a final order, and that's what's before the court this time, sir.
I understand that, but that was without my due process. So that's not right. Federal law states USC 38 is the law that governs disability benefits.
Okay, sir, okay, wait a second, sir. You're confusing two different things, looks like. Right now, I'm just telling you that the original court order in this matter that ordered you to pay child support is a final order under the laws of the state of Texas. All right?
My original, am I allowed to speak?
Yeah, go right ahead, sir.
My original order was signed 2016. I got out the Army and became a 100% disabled veteran in 2019. I never received my due process. The Secretary of the VA made a ruling, the only individual allowed to rule on veterans' disability compensation, not income compensation, made a ruling for $140 monthly, which the state attorney has just stated that they have received it, and she has agreed that she received that at the last hearing in her testimony. So it's not an allegation. She does get that $140 apportionment, which is a proper procedure to receive government funds. So I don't owe any alleged arrays. I don't owe any other child support. That $140 is the final ruling from the Secretary of the VA.
All right then, sir. Sir, I'm denying that. That's not correct. I know you're not a lawyer, but that's not even close to being correct, sir. There was a final order that originally ordered you to pay child support while you were in the military. Once you got out, that was still the final order. You now get VA disability. That's fine, sir. But the bottom line is that order is still final. What the commissioner or whatever, whoever over the VA ruled one way or the other, does not have jurisdiction or sway over this court. This is the state of Texas. This is not a federal court. This is a state court. And the state court, the information is well defined, sir, that you owe that money, and once it, and that's the final order of the court. The apportionment is the apportionment that the VA is giving toward that child support, not as child support, sir. The VA does not have any authority to grant child support in any state of the United States of America, sir. So, again, sir, that your interpretation of that is not correct, sir.
So does state law supersede federal law, Your Honor?
State law supersedes federal law where the state law, the federal government has given the states the authority to do so. And child support, visitation, custody, those are all state issues, sir. 100%. They are not federal issues whatsoever. And so all states, individual states have that right, sir.
So Texas Family Code is unconstitutional because their code infringes on my federal rights,
Well, sir,
which are governed by USC 38, which states.
Go ahead, sir. I'm waiting.
Which states, if I'm not retired and waive a portion of my retirement pay, all I receive is VA disability. Only the Secretary of the VA can make a ruling on those funds, not the state. And Rose versus Road is an old case. In my memorandum of law, I cited many recent case law studies. You can go over and read it. I mean, it's already been filed. And also to touch on the inability to afford court costs, I already submitted that form.
Okay, well, the state's gonna, since you're a veteran, sir, the court does not order veterans to pay court costs. But again, sir, your interpretation of this is not correct. That's gonna be my finding on this one. So you get a chance to take that down all the way to the Supreme Court of the state of Texas if you wish, but my interpretation of what you're telling the court is 100% incorrect, sir. Your child support is an obligation of the state. You were obligated to do so. You failed to do so, and you under the laws of the state of Texas, the state is requesting me to find that you owe mom that unpaid child support. They're requesting me to reduce that to a judgment in order of repayment, in order you to still maintain that going forward. And sir, I'm looking at putting you in jail if you don't abide by that court order. There's nothing under the federal statutes going to prevent me from doing that. So, yeah, you got a problem here, sir.
Well, I don't agree with what the state is saying, because that infringes on my federal laws. There's no way state law can supersede federal law. I mean, there's a document from the feds to the states, IM 98-03, that literally spells out the process for disabled veterans that receive compensation from the VA. You have to go through that process. I'm not retired. I'm 100% disabled. I don't waive any of my retirement pay to receive disability compensation. You stated that yourself in your opening statement, unless if we're talking about service-connected disabilities.
Here's the deal, sir. I'm not gonna sit here and argue with you all day about this. I'm getting ready to have a hearing to find that whether or not you have violated the court order for failure to pay child support. And at the end of that hearing, I'm allowed to send you over to Bell County Jail for 180 days, which means by the time you get out, you've lost your VA disability, because I know how that works too, sir. If you're sitting in jail, you're gonna end up losing it. And you have the absolute right to appeal anything I do. You have the absolute right to take it up as per you think is appropriate, sir. But I'm gonna tell you, going forward, based on what you requested the court to do today, will not suffice, and you will end up you'll probably end up in jail, and you'll end up having to serve that 180-day sentence, and you'll still owe the money. So again, sir, your interpretation of the federal statutes as far as how this works, as far as against the state order child support and failure to pay state order child support, the court is finding it's totally inappropriate, and I'm not granting any of your requests, sir. So with that on the record, sir, again, I'm looking at the state's looking at proceeding and asking you be held in contempt and sentenced to 180 days in jail for coercive contempt of $2,000 and change, and that's what's before the court at this point, sir.
Okay, I don't agree with the state's standing, so.
Well, here's the deal, sir. A lot of people don't agree with what the state says or what anybody says in a lot of court cases. I'm pretty sure everybody out in criminal court today may not agree with what those laws are, but they're going to end up in TDJC because they violated the law of the state of Texas. And right now, the state is alleging that you have violated the court order in this matter. And based on what I've read, sir, that's obvious as far as the payments have not been paid, and that child is your obligation, sir, and I'm going to enforce that obligation.
Okay, so the state literally stated, unless we're talking about service-connected disabilities, anything that they do after this, if they keep violating my federal rights, that's the Ultra-Virus Act. So
See, sir, you're trying to make me look over here, and I'm telling you we're over here.
I'm looking right at you, sir.
No, I'm talking about what you're talking about. The arguments you are making are not viable arguments for this venue, sir.
Okay, neither was the state's argument. He literally just said service-connected disabilities. That's the topic he brought up, so that's the topic I'm discussing. Because I get federal funds, not income. I get federal benefit, which is disability.
Yes, sir. And it's been well settled that the courts child support courts are allowed to look at your whatever disabilities you get from the federal government and calculating your child support. And that's not before the court at this time. That's not before the court at this time at all. The court has previously ordered you to pay child support. That's what's before the court at this time.
The only way someone can request money from a VA disability compensation
I did not order you to pay funds from VA compensation, sir. I ordered you to pay child support based on what your earnings were at the time of the original order. That's what that was. And that has never been modified. That has never been updated by you. There has never been a request by you to modify that before this at any time, sir. That's what's before the court, and that's what I'm basing any findings at this time on.
I disagree with the state's stand. I mean,
well, sir, you can disagree with it, but I'm probably getting ready to find that, sir. Is that thing on? Yeah, come here. Yes, sir. You. I've made several announcements today about cell phones not allowed out in the state in this court. If you're recording me, you can ready to go to jail.
Begging your pardon.
Oh, okay, I'm sorry.
My failure, Your Honor. I should have asked Mr. Jones to step out and check his phone. I apologize.
Okay, believe me, I just had somebody try to do that, and yeah.
Oh, no, that's part of your job.
Your Honor, you should probably be aware, I believe this is the case that I believe the last time we were here, you had admonished him about not recording. So.
Okay, well, again, that's one thing, I just want to make sure that tell the court anything you think is appropriate as far as your case is concerned. If you keep arguing federal statutes dealing with your VA disability when I'm sitting here looking at only the child support obligation is what I'm looking at. And you raise your right to first in the right now, it's not asking you to go to jail today, but I'm looking at possibly doing an order that's going to order you to repay child support, continue to pay child support, and if you do not abide by that order, you could end up going to jail, sir. You understand that?
I understand, and I disagree with the state and what you're telling me.
You disagree, all it's all, sir. And I'm reading it, and he says, with no child support order for child support, sir. You cannot get out of paying your child support by saying that you're only getting money from the services in your country through the VA. You cannot do that, sir.
It's in the federal statute.
No, listen, I'm not going to argue with you any longer, sir. I'm getting ready to go ahead and let the state put on their case in chief, and we'll take it from there. Sorry, sir. I'm through with opening statements. The state may proceed with their case in chief at this time. Thank you.
Thank you, Your Honor. And I should note for the court, the state was asking for instant for jail. So I
Tell them what that means.
so we were asking for you to go to jail today, sir. All right, Your Honor. State offers what's marked as State's Exhibit C. I marked it C because there was the country report on the last order had B. State has already given a copy to Mr. Chieti.
Please bring it forward. Thank you. All right, folks, this is State's Exhibit C. This shows what funds have been paid through the State Disbursement Unit in conformity with the prior orders of this court. Is there a legal reason under the Texas rules of evidence that this should not come in at this time, sir?
Yes.
Okay, I'm sorry?
Yes.
Okay, what's that reason under the Texas rules of evidence, sir?
Since Texas rules is unconstitutional to my federal rights, I have a VA apportionment ruling. The mom and the state attorney already acknowledged that she received that apportionment, which is a proper procedure to receive money from a veteran's disability compensation.
Your objection is overruled, sir. State C is admitted. I'm sorry, ma'am, do you have any objection? Ms. Griffin, you need to unmute yourself.
I'll press star 6, ma'am.
No, I have no objection.
All right, Exhibit C is admitted. May proceed, sir.
Thank you, Your Honor. The state calls Eli Adonis, sorry, not Eli, Burchell, Jamie Griffin.
All right, Ms. Griffin, please unmute yourself and raise your right hand. All right. Ma'am, do you solemnly swear or affirm the testimony you're gonna give this court today is the truth, the whole truth, and nothing but the truth will help you?
Yes, sir.
All right, you're officially under oath. The state's gonna ask you questions at this time, ma'am. Please listen to the question carefully and answer them to the best of your knowledge. If you do not know the answer, just let us know that, and I'll let the state move on from that question then. Thank you.
Yes, sir. Thank you.
What is your full name?
Rochelle Jenny Jones Art Griffin.
And just to be sure, can you hear me clearly?
Yes.
And ma'am, could you find a spot and not move around, because I'm afraid you're gonna lose yourself. Thank you.
I'm getting it on your phone.
Okay, thank you.
Your Honor, you want me to wait till she?
Yeah, let's wait till she gets to the vehicle. Thank you.
Yes.
She's in. Thank you.
All right, ma'am. So, as we were talking previously about the apportionment, so have you been receiving, $140 for the apportionment, from September 2024 to this month?
Yes.
And are you okay with giving, Mr. Chieti a credit for the 8 months of 140, toward his child support arrears?
Yes.
And so thus, do you agree with that apportionment, factored in to confirm child support arrears as of yesterday, April 15, 2025, at $18,779.56?
I believe so.
And do you agree to your payment on that? Do you agree to your payment on that of $144 per month starting May 1st, 2025?
Say again, do I agree that my payment what?
Do you agree to a repayment for that amount of $144 per month starting May 1st, 2025?
Do I agree for that to be just a payment?
No, ma'am, he's asking, is it okay with you for him to order, in addition to the regular child support, $144 a month for the repayment of the arrears?
Yes.
Okay, thank you.
And do you have any safety concerns with, Mr. Chieti?
At the moment, no.
And has Mr. Chieti ever been convicted of a family violence crime or something like that?
Say again?
Have you ever been convicted of a family violence crime?
No, sir.
And do you agree to confirm as of yesterday, medical arrears of $0?
Yes, sir.
And just so you understand, the financial report doesn't show that he's in any medical arrears, so you understand that?
Yes. He doesn't pay any medical, yes.
That's free healthcare.
All right, so, as you heard, the state is asking for him to go to jail today. With, 180 days, cash bond of $2,000, and also, besides that, he also be held in coercive contempt, with him need to be paying $2,000.34. What is your position on that? Are you fine with that?
Yes. Today. That would be great.
Sir?
We have a moment.
Yes. All right, ma'am, we're going off the record for just a moment. Thank you.
Yes, sir.
She's gonna keep him more than 60 days. She wants it on 40.
I'm sorry, just give us a couple more minutes.
And Your Honor, we're ready.
All right, we're back on the record on, Bell County College number 286,540.
Thank you, Your Honor. And so, ma'am, so for June 2024, July 2024, September 2024, and October 2024, besides the apportionments, has he ever given you any other kind of direct payments?
No.
That'd be it. Pass the witness, Your Honor.
All right, at this time, sir, the witness is yours. Do you have any questions of this witness?
No.
All right, thank you very much. Anything else of this witness then, Mr. Welch?
No, Your Honor.
All right, Mr. Welch, any other witnesses you wish to call at this time?
State would like to call Mr. Kuyate, Diana Sidi Kuyate.
All right, here's the deal, sir. You have the absolute right against self-incrimination. You can, any question that the state asks you, you can plead the fifth, or you can say, and for the purposes of this hearing, because you're not a lawyer and you don't understand the rules, that you would need to do that every time, I will allow you to make a cumulative request not to testify on the grounds that it would violate your Fifth Amendment rights to the United States Constitution for self-incrimination. Even though this is not a criminal case, this is a civil case. It's called a quasi-criminal case because you can go to jail, sir, and you are entitled not to testify unless you want to. So at this time, sir, do you wish to invoke your Fifth Amendment rights against self-incrimination, or do you wish to testify, sir?
I vote the fifth.
All right, the court will so find that the father, Mr. Gardner, has invoked his Fifth Amendment rights against self-incrimination. The court will grant that. So I just ask at this time, is there any other witnesses that the state wishes to call?
Rest, Your Honor.
All right, sir, you have the absolute right to call your own witnesses. You have invoked your Fifth Amendment rights, so you cannot testify technically to anything else that, you cannot testify, you can make arguments, but you cannot give the court testimony because you are, again, invoked your rights, and I'm not gonna allow the state to cross-examine you on anything. So at this time, sir, are there any witnesses you wish to call?
No.
All right then, sir, at this time, I'll ask the mom. Now, you're what we call a pro se litigant. You have the absolute right to testimony. You have the absolute right to call your own witnesses. I'll ask you first, is there anyone that you wish to call as a witness at this time?
Not at this moment, sir.
All right. Now, ma'am, based on what you've testified to previously and what you've heard so far today, is there any other testimony you wish to give the court in conformity with that information, ma'am? Anything?
I believe that Chairman Boy, I think they have a job.
Okay.
Real estate license.
Okay. You're aware of him having, you're aware that he has a real estate license, ma'am? Is that your testimony?
Yes.
All right. When's the last time that you noted that he noted he had a real estate license? Has that been recent, or has that been more than 2 or 3 years ago?
That was like last year when I worked at Brokerage. I worked at this license.
Anything else, ma'am?
Other than, oh, never mind. It doesn't apply to this court, but
Okay. We only do relevant things, ma'am, sorry.
yes.
All right, folks, I'm gonna listen to closing statements at this time and closing arguments. Obviously, the state gets to close last. I'll listen to, ma'am, if you wish to make a closing statement, Ms. Griffin, to tell the court what you want the court to do here today, like I say, you're the only rep, you'll be allowed to do so. And then if okay, we'll be allowed to make a closing argument, a closing statement also, and then the state. So I'm gonna start with you, ma'am. Anything in closing you want to ask the court to do here for your hearing? Are you asking for what the state's asking, or are you asking for anything in addition?
I'm definitely asking for what the state is asking for him to go to jail today, and also for him to provide me with my child's passport, as we did previously go to court a while ago, and told him that he would have to give that to me, and he refused. So, but yes, I do want him to go to jail today.
All right, thank you.
Thank you.
All right, sir, your turn.
In regards to the passport, this is probably 2-3 years old, and I told her exactly what happened. I moved, I don't have it anymore.
All right, well, again, sir, right now, that is not technically before the court. She had a right to make that in a closing statement, but right now, I'm not gonna be, I'm not looking at the passport circumstance. That's something for another day, sir.
In regards to the real estate license, I have a real estate license. It's inactive. That doesn't mean I work as an agent. Yes, I have a real estate license. I'm not working. So,
All right, but as far as your closing statement, sir, what do you ask the court to do here today? And again, sir, I've overruled your request based on federal statutes and what you said earlier. So, you can go ahead and reiterate those, and you can add anything else in addition to what you're asking the court to do here today based on that or anything else, sir. But this is your closing statement, closing argument at this time. Thank you.
so just to reiterate, this court does not have jurisdiction over my federal rights. Might be a compensation payment. And if you guys do decide to send me to jail, just make sure it's at least 60 days so she won't get that apportionment payment as well. That's it.
All right. State.
Your Honor, so the state is asking for the court to confirm child support arrears, with the, subtraction of that, of the apportionment that we discussed, at $18,779.56 as of, yesterday, with a repayment of $144 per month starting May 1st, 2025. They asked the court to confirm medical arrears at 0 as of the same day. And then, Your Honor, the state is asking for punitive contempt, for the failure to pay support, court-ordered support other than the apportionments we already discussed, for June, July, September, and October 2024. 180 days in jail, cash bond of $2,000, for him to go to jail immediately today, and also ask for coercive contempt, with the amount being $2,000.34. And Your Honor, that's 3 times the current support that he currently owes. The state does not see any kind of family violence involved, so the state isn't going to ask anything for non-disclosure. And Your Honor, you already know about his veteran status for the court costs, and the state abandons its request for attorney's fees. And Your Honor, I should note for the court that, that for several months in the pension report, there were no court order payments.
I'm sorry, what was that again, please?
No voluntary payments made.
Oh, okay, so you said there was no, okay, got it,
Yeah.
sorry.
And
All right, everybody, let me look over everything. Let me look at the pleadings one more time and double check the original order in this. And we're in a recess for about 30 minutes while I do that. Thank you.
thank you, Your Honor.
Judge, you're gonna order him to make sure he returns?
Sir, you're ordered to return. State's asking you to go to jail today, sir. You got somebody to come get the dog?
Yeah.
Okay, thank you.
judge so I can invoke my fifth when it comes to that, but he won't let me use federal laws when it comes to freaking. Wow. Fucking clowns.
I think there might be another file here that needs your signature, but I'll.
Does it say anywhere in your case that you're responsible for the remaining balance?
No, once you get, no. He literally just said, unless we're talking about service connected disabilities. So, just lying.
She wanted the opportunity to rebut if there's any kind of a issue with case request with she's a student in school and ex-school.
I'd use a bathroom.
Kind of busy. So, yeah.
That's the what's up. 30 minutes.
That's taking enough time. Come on, because I gotta go. Is there a bathroom close? Is there a restroom close? Oh, okay. Thank you. In the okay, thank you. Okay, thank you. Hey, get that food, too. They got the food. Get the food and I tried it. I gotta eat so bad.